Welcome everyone to Open Enrollment Comes But Once a Year. Thank you all so much for joining us. Our moderator for today's call is Chase Cannon. He will be answering the questions you send through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we are unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. We will be sharing the recordings in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday you will receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At this time, I'd like to introduce our speaker for today's webinar. Joining us today is Patrick Myers, Vice President and Counsel of Benefits Compliance at NFP. We're very excited to have him speaking with us today. It is my pleasure to hand over the call to our speaker. Patrick, the floor is yours.
Thank you, Amber. Good afternoon, everyone, and thank you for joining us today as we go through open enrollment. But before we get started, we have our obligatory disclaimer. Please note that the following is intended to be used for general guidance purposes only. It is not intended to constitute legal advice, nor is it a dispositive position on coverage. Each claim is subject to review by the applicable insurer, and coverage is dependent upon the terms and conditions of your specific insurance policy. With that out of the way, here are some faces to the names and the voices. Unfortunately, Kelly is unable to join us today. She's not feeling well, but you're stuck with me today. And as you can see, we're going to be covering a lot of ground over the next hour. But fortunately, I have a crack team of compliance experts standing by to answer your questions in the Q&A box. And so in addition to that, the slides and a recording of this presentation will be made available shortly after we're done today. So if you missed something or you have some additional questions, you can review that information later, or you can submit the question in our Q&A box. So let's get started. When you're talking about open enrollment, it's also a good time to think about whether or not to update or change the benefit plan. Under ERISA, group health plans must have a written plan document. Formats can vary, and they can take a lot of forms, and they include a separate plan document and a summary plan description, or SPD, a combined plan document, and SPD, which is okay if all the required ERISA language is included. There's the wrap, in which the ERISA provisions wrap the insurance and benefit materials together, or bundle documents where you combine two or more ERISA benefits in one plan. When it comes to the SPD, initially that SPD must be provided within 90 days of when a participant or a beneficiary becomes covered by the plan. And thereafter, it can be distributed. If there are no material plan changes to the plan, you still need to distribute it every 5 or 10 years. Although I can't imagine that being the case, or very usual that a plan is untouched for 5 years. But it may be preferable to distribute the SPD annually. There's certainly nothing in the ERISA regulations that prohibit this. If you do update or make changes to the plan, ERISA requires the plan administrator to provide timely notice to those participants and beneficiaries of the material plan changes made to those group health plans. Now, unfortunately, ERISA does not define what material means, but we think it's a good idea to think of what employees would need to know in order to make a benefit-related decision. For example, if the plan is if they're going to eliminate or reduce a benefit in a plan, or increase the amount the employee is going to pay for those benefits, or there's going to be new conditions or requirements imposed upon participants in order to obtain services, then those are going to be material changes that would require a timely notice. Now, the changes may be sponsor directed. That is, it may be made, these changes may be made because the plan sponsor wants to make some changes. Or those changes could result from requirements imposed by legislation from the state or the federal level. But regardless of the source of those changes, it is our observation that typically these changes are usually scheduled to occur for the new plan year. So this is a good time to think about whether or not those changes should be included and whether notice should be sent out to participants before open enrollment. Now, these changes can be provided in the SPD, and then that SPD can be distributed. But that's usually when if you're deciding to distribute the SPD annually. But the ERISA also provides for a summary of material modification, which is a standalone document that explains the specific plan change to participants. Now, in addition to those changes, federal agencies often will update limits on an annual basis. For instance, HSA or FSA contribution maximums. So you want to make sure that your enrollment systems and the enrollment guides are updated to reflect those limits, those new changes. The plan document in the SPD may also need to be updated if those documents contain specific dollar amounts. So it's a good idea to check those documents to make sure that those changes are accurately updated and reflected in them. It's also a good idea to review the materials to make sure that employees are alerted to any use or lose provisions, such as with an FSA. We have included a slide in our presentation that updates or reflects some of the annual limits for this year as well as next year, some of the more important ones. I won't go over them individually here, but again, you will receive slides at the end of this presentation. And so this is something that you can refer to later if you need to know some specific numbers. In addition, we have a white paper that summarizes not just those limits that are reflected in the slide, in the previous slide, but some additional annual limits as well. So that's also available upon request. So now let's talk about which notices should be distributed during open enrollment. There are several notices that have to be distributed annually, and these include the CHIP notice, the Reasonable Alternative Standard Notice for wellness plans, the EEOC Wellness Notice for wellness plans, the Summary of Benefits and Coverage, or SBC, the Women's Health and Cancer Rights Notice, and the Medicare Part D Disclosure Notice. And we're going to drill down into a few details about these notices in the upcoming slides. The CHIP notice notifies employees of the right to enroll in the plan if they lose Medicaid or CHIP or become eligible for premium assistance through Medicaid or CHIP programs. And as I mentioned, this is to be provided annually and applies based on the state where the employee lives. Now, also note that this slide has a snapshot of the first part of the model CHIP notice, which of course includes particular information for every state in which it applies. You'll also notice that we have included here a link to the website where the Department of Labor maintains the model CHIP notice, which does change on occasion. So it's a good idea to check to make sure that you're using the current model notice. The next notice we'll be discussing are the wellness notices. And the first one is the Reasonable Alternative Standard Notice. And this is the notice that is used when there's a health contingent requirement. For instance, if there's a walking program or a tobacco surcharge, biometric screening, and the like. In fact, a wellness program is not considered to be HIPAA compliant without this notice. The other thing to keep in mind here, and this will come up later also, is that the notice has to be included in all materials assessing the wellness program, not just with the materials that are submitted or provided during open enrollment. The next wellness notice we discuss here is the EEOC wellness notice. And this is required if the wellness plan includes a medical inquiry. For example, if a biometric screening or health risk assessment is required. We note here that this notice has been subject to some litigation, but despite the court challenges, this requirement has not been invalidated, and so it's still required. Even employers who have a wellness program that is administered by their insurer should make sure that this notice is being distributed. In addition to that, you should make sure that it is distributed before the employee has to complete that medical inquiry. And you'll also note that on this slide, we provide a link to the website where the EEOC maintains this model wellness notice. The next annual notice we'd like to discuss here is the Summary of Benefits and Coverage, or the SBC, which is a requirement under the ACA. It's required during open enrollment, and it consists of a 5-page document that summarizes plan benefits. And the template for this SBC is provided by the DOL, and you can see a snapshot of that here on the slide. Now, note that this is a requirement that's imposed on both the employer and the insurer. So employers should make sure that if the insurer is going to be distributing it, that it is distributed. And also note that we have, again, another link here from the Department of Labor website where the SBC template is maintained. The next notice is the Women's Health and Cancer Rights Notice. Plans that provide medical and surgical mastectomy benefits must notify participants of benefits for reconstructive surgery, prosthesis, and physical complications. Now, this notice can be included in the SPD, and that will apply for the annual notice requirement if the SPD is distributed annually. And this slide also includes some model annual notice language that you can refer back to later when you get the access to the slides. And finally, the Medicare Part D disclosure notice. Now, this is the notice the plan sponsor distributes to all Medicare Part D eligible individuals. The safest bet is to assume that everybody gets a copy of this notice, regardless of whether or not you know if they're in fact eligible for Medicare Part D. And it's a useful document for those persons to have so that they can make an informed decision as to whether or not they need to enroll in Medicare Part D. Because if they fail to enroll, if they don't have creditable coverage, and they fail to enroll in Medicare Part D in a timely manner, then they may find themselves with some penalties. So it's a good idea to make sure that these notices are timely distributed to everyone. Now, these are distributed at several points, or they can be distributed at several points. First is on an annual basis prior to October 15th, which is the deadline for enrolling in Medicare Part D. And some employers choose to include this in their annual enrollment materials, although you want to be careful here because depending on the timing of the open enrollment, it may not meet the timing requirement here. So you want to make sure that if you're doing this, that they are distributed, the materials are distributed before October the 15th. It can also be distributed prior to an individual's initial enrollment period for Part D, when the individual originally becomes eligible under the group plan, upon a change in the plan's creditable status, including if the drug plan is terminated, and upon the individual's request. And again, we have a link here to the site maintained by the CMS that contains credible coverage model notice letters. So what notices are not required to be distributed annually? Well, among those include the HIPAA notice of special enrollment rights, the exchange notice, which is distributed to new hires regardless of their benefit eligibility, which lets new hires know of their right to obtain insurance on marketplace exchanges, the FMLA general and initial notice, the COBRA general or initial notice, which remember should go to the spouse, the HIPAA notice of privacy practices, and then there are several other notices that are required under federal law that can be included or should be included in the SPD, which, for instance, the Newborns and Mothers Health Protection Act, patient protections, and internal claims and appeals notes. We have a couple of resources that helpfully summarize that information regarding both required notices and other notices, as well as a chart that presents this information in chart form, which is a really handy resource if you need to check to make sure that you're distributing the notices at the appropriate time. So once you understand which notices have to be distributed, the next thing to consider is when those notices should be distributed. And how should they be provided? Well, there's several ways that can be done. And it's a good idea to think carefully about the different methods to distribute them in order to make sure that everybody gets the notices that they need to get when they need to get them. Of course, you could do it hand delivery, but that's rarely cost effective, especially if you've got a remote workforce. It just may be more administratively and logistically difficult to do it this way, but you could do it. First class mail is always a good option. Email is okay if certain conditions are met. And we'll talk a little bit about electronic distribution here in a minute. You could also post these notices on your intranet, but you've got to be careful about this because, again, you want to make sure you comply with electronic disclosure rules, which, again, I'll discuss here in a moment. And you also want to make sure that your employees are alerted that those notices are posted on the intranet, as well as being provided a way of getting to those pages on the intranet where those notices are posted. And you could also provide those notices as part of the enrollment process, for instance, as part of the benefit enrollment guide. And that's okay for many notices, but not necessarily for all of them. So you want to make sure that when you go through each notice and you're considering how you're going to distribute them, whether or not you want to put those in your enrollment guides. So let's take a few moments to talk about those electronic distribution rules. The general idea here is that the Department of Labor will allow you to distribute these notices or other ERISA-related documents electronically if the employees you distribute them to have access to a computer as part of their workday. That is to say, they're sitting in front of the computer all day, answering emails and doing the like. Those are the kinds of employees that can receive their notices electronically. But again, when you're talking about these kinds of employees, you want to make sure that those employees are aware that those documents are available. You want to make sure that they're aware of the significance of those particular documents if the significance of those documents are not automatically or immediately apparent. And also, those employees still have a right to receive paper copies of those documents upon request. So even if they receive this information electronically, they should also be aware of that right to receive the paper copy. Now, those employees who don't have daily access or regular access to computers during their workday, for instance, they work out in the field, then they can still receive these forms electronically if they give affirmative consent. And the consent has to include things like information such as the types of documents that will be sent electronically, that it informs those employees of the right to withdraw this consent and identifying the process of how to go about withdrawing that consent. It has to inform them of their right to receive paper copies, much like the electronic distribution, and make sure that the hardware or software necessary to access the documents are available to those employees. Now, another thing to keep in mind is that if you've got employees who, say, work on a factory floor and might have access to a kiosk where they could go to a computer, that by itself is probably not going to be sufficient to make them employees that have access to their computers all day. So those are employees that will probably need to obtain, or you'll need to obtain consent from those employees to distribute those notices electronically. And again, you must alert the employee of the availability of those documents and the significance of those documents if the significance of those documents is not immediately apparent. So to paraphrase Ian Malcolm of Jurassic Park, you might be able to distribute these electronically, but you need to consider whether you should deliver them electronically. So we have a list here of some forms that should be just fine for electronic delivery, and then there are some that you should think twice about before sending electronically. For instance, CHIP notices, the HIPAA notice of special enrollment rights, the Medicare Part D notice, the notice of exchange, your SBD, your SBC, your SMM, that summary of material modification, as well as your SAR, or your summary of the annual report, as well as those wellness notices that we discussed. Those are fine for electronic delivery. But forms like the COBRA initial notice and election notices, especially since the election or the initial notice has to go to the enrolled spouse, you should think twice about sending those electronically. First class mail might be the better way to go. The other thing you want to consider when we're talking about the COBRA election notice is that those employees are typically not employed when they get those election notices, so they may not have access to electronic documents. So first class mail may be the best way to go there. In addition, the FMLA notice of non-payment of premium should likely be distributed by first class mail, because again, the employee who is on FMLA leave may not have access to electronic documentation. In addition, the HIPAA wellness plan notice of reasonable alternative, which we discussed a few slides ago, as we mentioned then, they have to be put in all wellness plan materials, not just open enrollment guides or annual enrollment. So those are probably not good candidates for electronic delivery. So regardless of the method that you use to distribute these notices, you also need to consider how to verify the receipt and maintain records of receipt of the delivery of those records. Electronic delivery must be reasonably designed to ensure actual receipt. The plan administrator should have a procedure in place to keep track of who they sent the notices to and who has received those notices. For instance, a certificate of mailing or a log of notices that have been sent. And document delivery can be an important issue in benefits litigation. So the plans administrator should keep records to show that the plan followed an acceptable method of distributing and maintaining records of distributing those notices. So at this point, we're about halfway through, and this might be a good time to take a pause and see if there have been any questions that we can answer here during the presentation. Chase, are there any questions that we should address now?
Yeah, thanks. Thanks, Patrick. And big Jurassic Park fan here as well, so I appreciate that, that call out there. So a couple of good questions, and I think you answered this first one, but just getting back to that idea of whether you can just place an SPD or really any of these notices on the intranet, whether that's sufficient. And I think you could add to that like employee portal, where they might see it, but they might not. And I think you spoke to it, but just that idea of, not quite sufficient to just throw it out there and expect people to get it.
Right.
But any additional thoughts on that?
Well, again, it's just a good idea to also follow up with some additional notification to the employees that those documents are on the intranet, and maybe provide them with a link to the specific page on the intranet where that's being hosted.
Yeah. So lots of times we'll just say, look, you gotta send an email or some type of notice letting them know it's there anyway. You might as well just include it, especially if it's an email, just add the notice as a PDF attachment, right? Because then you're kind of going the extra mile and making sure, and if you have to send that email anyways, maybe it doesn't make sense to have it in two places. But yeah, thanks for that. So another question had to do with, what do we mean by during open enrollment? Does that mean like the beginning, the end, the middle? And I think what we mean, and you can confirm, I think what we mean is with open enrollment materials when we say that.
Well, I think it kind of depends on the context. For instance, when I discussed making plan changes, obviously or naturally that would fall before you would even distribute open enrollment materials, because if you're going to make any changes, you want to make sure that those materials reflect those changes. But context is key there, so that's a good point.
Yeah. We had some questions come in on the size of the employer. Does that matter? With respect to, the question was specifically about an SPD. Would that apply to employers under 50? And I thought this was a really good point, because there are some notices that we've talked about that might not apply based on size. I think those would be, you would naturally know whether you were subject to COBRA. If you were under 20 employees, you would not have COBRA notice obligations. And similar with FMLA, with a little higher employee count, but the SPD is an ERISA requirement, which applies regardless of size.
Right. Right. And spoiler alert, I will be talking a little bit about some instances where size would matter.
Yeah.
But yeah, we're not where the SPD is concerned.
Right. Okay. And then another good question here for annual notices that are, when we say they're fine for e-delivery, is it okay if the employee does not, if the employee does not have a company computer or email? Can they simply be told where to find them? And I think we just want to clarify on that question that just because we're saying it's fine for e-delivery, you still have to make sure that the employee has that access to computer, to company computer or company email. You can't just because we're saying it's okay for e-delivery does not mean you can just send it to all employees like that. You still have to check that box that the employee has access. Or if they don't have access, they've provided permission to send notices to a personal email. We have seen that before, but that's usually a less likely scenario. Usually, if you have those employees that do not have email or work, think of like a warehouse type of worker where they just log in, do their work, and leave. They don't really have access to a computer. For those employees, probably best to just go with mail. Any other thoughts on that?
No, I agree. And just because when we talked about which notices can be sent electronically, that would, of course, I guess I should be clear to say that presupposes that they would otherwise comply with electronic disclosure rules. We were really focusing on that slide on other issues that might be attendant to that notice. For instance, the COBRA election notice, the person may not even be employed and may not have access to electronic documents. So it's a good idea to send those by mail, that sort of thing. But yes, like for the CHIP notice and the HIPAA notices and stuff like that, it's a good idea that you should still also make sure that you are complying with electronic disclosure rules first.
Yeah. And then just a couple of notes, I guess, from questions that came in regarding actual due dates. Oftentimes that Medicare Part D notice that's going to employees, the law uses this term prior to October 15th, which is kind of confusing, right? What does that mean prior to? We usually just say October 14th due date if we're trying to be really clear, but it's possible that you could send it, before that even, but that's just one clarification. It's October 14th, and you may see that date out there. That's the actual due date because that's the last day prior to October 15th. And then the other note would be on due dates that fall on weekends. Sometimes that can cause confusion or a holiday, right? And generally speaking, those roll over to the next business day. So I just want to make that clarification.
Right, thank you.
Yeah, so I think that's probably it for now. There's some more coming in, but I think that's we can catch these at the back end as well after your next section here.
Okay. Well, thank you, Chase. Well, as promised, this next section we're going to be talking about how you document your offer of coverage. And here we're referring specifically to the employer mandate. Applicable large employers have to offer coverage to full-time employees under the employer mandate. And an applicable large employer is defined as an employer that employs 50 or more full-time employees. And that does include full-time equivalent employees, which you determine applying a particular formula under the employer mandate rules. Now, if an employee receives a premium tax credit, that is, they go to the marketplace and they get individual coverage and get a subsidy from the federal government to pay for that coverage, then that could expose the employer to a penalty if that employer did not, in fact, offer that employee coverage. So how do you prove that you've offered those employees coverage? Well, unfortunately, the regulations don't really specify how you're to document that proof, at least sufficient to satisfy this requirement. And unfortunately, IRS is actively enforcing the employer mandate with their 226J letters. It's been an observation that the best practice is just to get a signed waiver of coverage from those employees who decline the offer of coverage from the employer. But when we're talking about coverage, we also don't want to forget about affordability, which is also part of the employer mandate. That coverage that is offered to employees must also be affordable. And affordable is defined under the regulations as the lowest cost of self-only coverage, and that must be no more than 9.5% of the employee's income. Now, that 9.5% is adjusted for inflation. This year, it's actually 9.61%, and next year it's going to be 9.12% of the employee's income. And how is that determined? Well, there are several safe harbors that are available under the federal regulations. There's the federal poverty level, the Form W-2 safe harbor, or the rate of pay safe harbor. And remember that cash out options, that is the option to cash out rather than take benefits, as well as wellness programs and the surcharges and incentives that can be offered under a wellness program, can affect affordability under certain circumstances. And don't forget the people that you can't see. That is, those people may not be actively in the office or at work. They also need to be taken into consideration when it comes to open enrollment. A big subsection of those would be people who are COBRA participants. If you're a COBRA participant, you're entitled to participate in open enrollment just like active participants. So COBRA participants should receive open enrollment materials as well as an opportunity to make those annual elections. Now, remember, a newly enrolled employee and spouse must also receive that COBRA initial notice within 90 days of their participation in the health plan. This would not only include those who enroll as new hires, but those who enroll a spouse later following marriage or during an open enrollment. In addition to those COBRA participants, employees who are on FMLA leave are also entitled to participate in open enrollment. So you should provide employees on FMLA leave with enrollment materials and give them an opportunity to enroll if they would otherwise be eligible for the benefits. Remember, anyone that is entitled to coverage but may be on leave or not an active employee. So in addition to the COBRA participants and FMLA people on FMLA leave, retirees may fall into this category. Employees who are on state leaves or on disability leave, people who are subject to qualified medical child support orders, are also all people that may need open enrollment materials and may be entitled to participate in the enrollment. Bottom line here is the rule of thumb is if the person is entitled to coverage under the plan for the new year, they should receive an open enrollment packet. So now let's move on and dig under the hood a little bit and discuss some cafeteria plan rules. Cafeteria plans are governed by Internal Revenue Code Section 125. And Section 125 plans are typically referred to as cafeteria plans. And these are plans in which participants can pay for their contributions towards benefits on a pre-tax basis. And Section 125 imposes a lot of rules and requirements in order for cafeteria plans, and those include the requirement that every participant get an opportunity to make selections once a year. It also provides that there are certain circumstances where participants can make changes or enroll outside of the open enrollment period, provided that certain qualifying events occur. And it also imposes limits and rules for FSAs and dependent care FSAs. And then in addition, Section 125 also includes non-discrimination rules, which is to say benefits that are offered under cafeteria plans cannot discriminate in favor of highly compensated employees. So let's talk a little bit about changes that were made outside of open enrollment under Section 125. Now, regulations don't dictate when an open enrollment should occur. That's going to be up to the employer and its plan design. But remember that elections must always be prospective and made prior to the beginning of the plan year. The employer may allow changes between open enrollment and the start of the plan year, but they don't have to. And no changes are allowed after the start of the plan year unless there is a qualifying event. There is no grace period under Section 125. But what happens if the participant makes their choices during open enrollment, but makes a mistake or commits an error when enrolling during the open enrollment period? The employer might be able to make some changes after the start of the plan year if there is clear and convincing evidence of a mistake or error. It's a clear mistake, for instance, if an employee is ineligible for the coverage that they chose. Unfortunately, buyer's remorse is not a mistake or error that would allow for a changed election. But the general IRS guidance here is that a mistake should be corrected in such a way as to put the parties in place or in the same place they would have been absent the error. So that's kind of the general guideline to keep in mind when correcting a mistake. It's also important to identify whether there truly was an error or a clear mistake. And correcting, and also keep in mind that the timing is important here too. Correcting, withholding, or salary reductions is much easier in the same year as the election is made. If it's found after the year end, then that could require amended W-2s and employment tax filings and the like. So it's really important to try to keep track of these things and make those corrections before the end of the year when things get much more difficult to change. So here are some examples of some true mistakes that we've seen, or we've often seen when we're dealing with these issues. When determining whether there's a clear and convincing evidence of a mistake, some things to consider are the employee's past elections and benefit usage, and look at plausible evidence of a clerical mistake. For instance, $5,000 input into the system, which could have been $500 or even $50, but not likely $1,390, for instance. Assess the employee's truthfulness, and that's kind of a context thing, but it's a good thing to keep in mind. The time that's elapsed between the first payroll date after the election was in force, changed circumstances experienced by the employee that might be evidence of reconsideration rather than an actual clerical mistake. And it's also good to look at other extrinsic evidence of a mistake before making that determination. So now let's move on to another related topic, which involves HSA eligibility. This is a good time to take a look at HSA eligibility with an eye towards helping employees protect their ability to contribute to their HSAs. The general rule of HSA eligibility is that HSAs are allowed if the employee has an HDHP or a high deductible health plan and no impermissible coverage. A high deductible health plan has to meet certain prescribed limits, deductible limits and out-of-pocket limits. And employees can only enroll in HSAs if they have a HDHP. Now, impermissible coverage is defined as coverage that's provided before the plan deductible is met, other than preventive care. Examples include general purpose health FSA coverage of either the employee or the spouse, Medicare, and this is kind of tricky because, when it comes to Part A, there is a possible retroactive application of Part A. So there could be months where that are covered by Medicare when they weren't, they might have enrolled in Medicare Part A, and then that Medicare then is retroactive several months. Or another medical plan. For instance, the spouse covers the employee with a traditional plan under the spouse's plan. Contribution and catch-ups are prorated for mid-year enrollments. And the employer should consider clear warnings of impermissible coverage in enrollment materials and or the system. So it's a good idea to take a look at the materials that are and the things that are offered to employees with an eye towards making sure that the employees are aware that certain things may render them ineligible for HSAs. It's important to remember that employer contributions should be clearly spelled out and in materials to the employee, including what happens to contributions if an employee has not yet opened an HSA, or how contributions may be prorated for new hires. Now, HSAs are generally not subject to ERISA, but the underlying HDHP is. So to prevent an HSA program from becoming an ERISA plan, the employer should limit involvement and be careful not to communicate that the HSA is subject to ERISA, to make sure they're not make those employee contributions involuntary, influence HSA investment decisions, impose conditions on use or transfer of HSA funds, receive payments in connection with HSAs. Now, and the employer also is obligated to forward HSA contributions in a timely manner. Now, if late contributions are made, then voluntary fiduciary corrective programs should be available to allow the employer to determine the dates that funds should have been placed in the HSA, calculate lost earnings and interest, and then enable the employer to remit those funds into the HSA. Now, the HSA is the employee's account, and the employee is responsible for knowing the eligibility. And the employee may have to set up the account themselves, and the communications to the employee should be explained if set up is not part of the enrollment process. That is, the employee should be made aware that they have to set this thing up themselves, and it's not going to be automatic. Now, the employee also experiences tax consequences of ineligible contributions and distributions. So it's helpful for that the employee be aware that they need to monitor whether or not they have impermissible coverage, and whether or not other circumstances may apply that may make a contribution ineligible. So it's a good idea that communications be open about that. So now let's discuss briefly how to certify employee-provided information during the enrollment process. Now, the IRS does not require any specific documentation to prove dependent or spouse eligibility or to prove a qualifying event. Affidavits may suffice for this purpose, but the employer can request documentation. If the employer does require documentation, they should be consistent in their application of the requirement. And consider an open enrollment system and what it's capable of when you're considering what kind of documentation, if any, is going to be required. Can documentation be attached for verification purposes? And can the system notify employers or dependents that have aged out? So those are some issues that need to be taken into account. But also remember your fiduciary obligations. Bottom line here is the plan sponsor is often responsible. Many vendors and service providers, of course, assist employers with open enrollment, but ultimately the employer is the plan fiduciary and is responsible for what occurs or does not occur. Typically, your third-party administrator or TPA is not a fiduciary and acts at the direction of the plan sponsor. The plan sponsor can delegate responsibility as permitted under the plan document, but ultimately will still have the duty to monitor the service providers to make sure that they are doing everything in accordance with the plan documents. Because again, even if the service provider makes an error, as the fiduciary, the employer or plan sponsor is going to be ultimately responsible for those mistakes. Notice requirements and offers of coverage are not just a check the box activity. So the plan sponsor should review all disclosures for accuracy, oversee the enrollment process, and maintain good records. And with that in mind, you should design open enrollment to fit the company. For instance, should weigh whether paper enrollment or a benefit administrative system enrollment would work best for the company. Which one will minimize errors? Is the benefit administrative system that under a review up to the task? Are employees comfortable with the benefit administrative system? Or are they used to having paper to fill out and to read? Is the employer considering a passive or active enrollment? So these are the considerations that should be taken into account when designing the open enrollment program, and also should be discussed with the employer when designing those systems. So open enrollment choices also include whether an in-person enrollment meeting versus an enrollment guide mailing versus electronic distribution. Will all employees attend the meetings? Are there too many employees to mail a guide? Has the employer met the Department of Labor's electronic distribution safe harbor rules that we discussed earlier? And can the employer prove notices were received by everyone? So again, these are questions that should be taken into account when considering open enrollment and open enrollment processes. So we've covered a lot of ground here, but do we have any additional questions that we can cover during the time that we have remaining?
Yes, Patrick, take a break for a sec. That is a lot for you, and we certainly appreciate you walking through all of this. This is really helpful information. I wanted to address a couple of questions to kind of give you a quick break for a sec, and then I'll lob some back to you. Take a drink of water though, and but the first one was just talking generally about this idea of when you're talking fiduciary obligations, and just that idea of trying to operate the plan in the best interest of your plan participants and beneficiaries, and following the plan terms as you operate. I wanted to take that and kind of apply it to this idea of avoiding mistakes during open enrollment. And you covered that very well, and sort of this idea of what mistakes can employers go back and fix following an open enrollment, these clerical errors, these clear mistakes that come up. There's always going to be pressure to make exceptions for important people within the company or in certain situations. And employers really just have to remember that you have to balance those two. You have this obligation to follow the plan terms, to follow the IRS rules that say, generally speaking, you cannot change elections, but also in the best interest, if there are these true mistakes, to go back and fix those, because that's in the best interest of everybody to make sure that an election error or the wrong amount being withheld from salary, those are mistakes you can fix, but you want to fix them right away, because that helps avoid this idea that there's some other reason that you might be fixing them, or some other reason that the employee might be requesting them. And so I just wrote down a couple of things that came to my mind quick based on some recent conversations I've had with clients, but doing a quick audit right after open enrollment to make sure, especially if you're doing something online and you have a way to verify with the administrator, just the actual elections coming in from employees, verifying that that's what actually got transmitted over to the administrator is one way you could do that. Another is to communicate with employees to verify the correct deductions directly after open enrollment. That doesn't mean you have to go verify with every single employee, but maybe just a quick email from the employee benefits team or the HR team saying, hey, we just want to remind you to go double check your elections now that deductions are being taken from your paycheck. Because so often what we hear is the employee didn't hear about or didn't bring this up for months and months, sometimes a year later. And when you're analyzing whether to correct that error, you do have to take into account the time. Why didn't the employee notice the difference in pay for 6 months? That's a factor that the employer would have to weigh. So those were just a couple of notes to talk about the avoiding mistakes. A couple of others, how can you verify the COBRA notice being delivered to a spouse? And we're talking generally about the COBRA initial notice. And that gets back to this idea of, do you have to actually deliver it to the spouse? And that initial notice can go in the same envelope as the one to the employee, but it should be addressed to both. And the only exception there would be is if the employee is aware that the employee and spouse are actually living at separate or located at separate addresses. So I thought that was an interesting one.
Yeah.
COBRA notices can be tricky too. You mentioned, Patrick, that idea of a mid-year spouse enrollment, right, after a marriage, and that newly enrolled spouse needs to get that COBRA notice as well. That's one that's forgotten a lot.
Right.
What about remote workers? This is something that's come up a lot recently, and notices. For remote workers, you still have the option to send things via email or mail, but I think one aspect that comes up that sometimes gets forgotten in this new environment we're in with so many different remote workers moving to different states is that, and we've talked all about federal notices today, but don't forget about those state notices, right? If an employee is working in a state like Massachusetts, like California, lots of these, New York, a lot of these states have these paid family and medical leave laws or a disability law. There may be a notice associated with that. I don't know, Patrick, you probably had a lot of conversations with clients and with our offices about those type of challenges with remote work. But if you don't mind just kind of sharing your thoughts on that.
Well, I agree that those are considerations that can trip you up if you're not careful. Yeah, it's a good idea to review what the state requirements are as well, to make sure that those appropriate notices are also distributed to remote workers. But as far as electronic distribution of notices to remote workers is concerned, I suppose it's possible that workers who are remote, that is, they're in other states, do not have access or use computers as part of their daily workload. But it's probably more likely than not that they are employees that would be able to receive electronic notices under the electronic disclosure safe harbor rules. So typically that is usually not an issue, but it is a good idea to double check that.
Yeah, that's a great point for sure. Okay, there were quite a few questions on the Medicare Part D notice that I thought were interesting and worth going back to. The first one is one that, thanks to Kelly, we have Kelly and Carol and Jill have been doing an amazing job answering questions that are coming in, but this was an interesting one. Is there a newer version of that Medicare Part D notice to individuals? The last one is from 2011, so 11 years ago, and the answer there, which Patrick, I didn't know off the top of my head, is that that's actually the most recent version. So if you are seeing a version and it has that old date, generally we say, go check the DOL or the CMS or the HHS website. We can hook you up through your NFP account executive to make sure you're getting the most recent version. But in that case, that is the most recent version.
Yeah.
Usually they get updated a lot more often, right?
Yeah, it doesn't surprise me.
Yeah. So another question on the Medicare Part D is whether that needs to, how do you know which employees are Medicare eligible? And I think our response there is we generally say, send it to all employees, all eligible employees. Again, that can include, as you highlighted, COBRA participants or participants who are, retirees. But the easiest, it's similar to the CHIP notice that we say that's technically only has to go out to employees in states that have that CHIP program, but it's so hard to identify and remember and then figure out employees are in those states. Same thing here, right? Just send it to everybody because it's better to cover all your bases in that way.
Right. Agreed. It's usually just safer to send it to everyone.
Yeah. And then there was a question about the CMS Part D disclosure. There's those two disclosures, right? We've been focusing on the notices that go to employees, and there's actually a second part of that Part D disclosure. It's the filing with CMS. Just wanted to re-highlight that is not necessarily a notice requirement. It's filing with CMS, letting them know whether the coverage is creditable or not. And that is just logging on and doing a filing with CMS, and it has to be done within 60 days after the plan year start date. There is some confusion out there with 90 days or 6 months. I've seen several, or it has to be done by the first day of the plan year. The due date for that one is within 60 days after the plan year start date.
Correct. That's not something that that individual employees need to concern themselves with.
Yeah, so I think that probably gets us to the top of the hour here, and we can, unless you had any other closing comments, Patrick.
No, I think we've covered everything we can cover in an hour. I appreciate everyone joining us today, and we all hope that you have a great day.
Well, thank you, Patrick, for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded. We'll be sharing the recording and the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you will receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey, as it lets us know what topics are important to our listeners and helps make our education program as current and relevant as possible. That concludes our webinar for today. Thank you, everyone, for joining us, and have a great day.